Usable Net actually releases a report every 6 months. And this report is telling us about what the risks are, not giving legal advice. They're not trying to be attorneys or anything like that, but they're giving us this report to let us know what the landscape is like and what is our, so it's more of a compliance report or a risk management report as opposed to really any legalities of it. Okay. It's a very fine line they're walking, but hey, what can you do? The report pretty much it provides like an overview of pretty much the lawsuits that were filed in the state and as well as the federal court under the ADA or the Americans with Disability Act, as well as some lawsuits that were filed in California under the UNRRA Civil Rights Act. And the research conducted an investigation of the status of the circumstances from January through June of this year, of 2022. So just to explain a little bit about the UNRRA Civil Rights Act is a California civil code. It's in actually like section 51 if you want to go take a look. It's a state act that provides protection from discrimination by all businesses, establishments in California, blah, blah, just like ABA does, including housing, public accommodations, age, including ancestry as well, race, gender, disability, national origin, whatever. The California Supreme Court, they had repeatedly interpreted the law as protecting classes other than those listed on their list that they put to. So this is a protected class act. Anyone who's in a protected class, that even means those who are homeless, but those are protected classes, even though the act does not explicitly state that, it even applies to them. For example, the California Supreme Court decided that the act outlaws sex-based prices at bars, such as like that whole ladies' night debacle. Remember that? Where they were offering a discount on drinks, but not offering the same discount to the men. Uh, it was actually in 1985. The first lawsuit in that was 1985. That was Carr versus Metro Car. I remember that one. That I had a little bit of research on that. But the court held that these type of discounts they constituted sexual stereotypes and they are prohibited by that state act. That's why some states have ladies' night, like ladies getting free or ladies get half off on drinks, stuff like that. And some states don't because it's actually illegal in some states. You can't do that. Very few states adhere to it, but there are a few that do. And California's one, New Jersey's one. I'm sure there's others. Uh, the act and law was put in place just due to them having a higher amount of country clubs than any other states, and the country clubs were drastically discriminatory against women, people of color, and those who identified as Jewish. So that was originally what the act was put in place for. However, Car versus Metro Car Wash, they had came in and Metro Car Wash was a lawsuit where Core went in and said, hey, why are ladies getting discounts for car washes and men aren't? Got it, understand that's not fair. And they're right, it's not fair. Everyone should get a discount or no one gets a discount, right? It should not be based, I don't say sex because sex is not the appropriate term for gender. But back when this act was in place, we were still using the term sex to stand for gender. Let's see. That's enough of me rambling on. Somebody have a question? I can't see it.
Oh, yeah. So,
Okay.
is that similar? Well, two questions. What
Sure.
does UNRRA mean?
UNRRA, I think, is the individual who is one of the individuals who brought it back up for the act. I think that was their last name.
Okay.
Yeah.
And then is this similar to when I lived in the LA area? I remember there being discussions about how men receive discounts on dry cleaning and haircuts. Is that similar?
Yeah, a lot of states you cannot do that. Everyone's supposed to get a discount on haircut, and everyone gets. It can't be gender based in a lot of states. California specifically, I know New Jersey is another one. You might want to check your state, whatever state you're in. Virginia and DC, we can still do gender based discounts here, so there still are ladies' nights, and there still are gender based discounts. Go ahead, go
Oh,
ahead.
what if it's not put through as a discount, though? If they just charge men less for their dry cleaning, for example?
Yeah,
Y-
that's discriminatory. It's like if we find out about it, you can be sued. That's discrimination.
Okay, cool.
That's like saying you're of European descent and Jay is of I don't know, he's androgynous. I'm not sure what Jay is of his descent. He's brown. He's a brown person. And let's say that you of European, I'm charging you less without letting Jay know. And
Mhm.
then I am on the sideline. I'm like, hey, she just charged her less than she charged him because of it has to be because she's European. I wouldn't know if it's because you're European descent or if it's because you're a woman. I wouldn't know the difference. All I know is you're getting less charged for the same product or the same item.
So it's kind of based on whether people find out about it then. If it's
Technically. But you know what? For the ladies' nights and all that, they have to advertise.
Yeah, but I just remember that when I lived in LA area, there it was talk going around that men were charged less. It wasn't like they were
Yeah, yeah, and you know what? It's nothing we can do if no one if I'm gonna charge you $10 for a haircut and then the next lady that sits down I charge her $20 and no one is standing by and notices that they were charged different. No one says anything. Yeah, absolutely, you can get away with that.
okay.
Yeah, it's unfortunate. Ladies' nights, I'm kind of on the fence about that because that could mean several different things. Because and that doesn't even mean for nightclubs. I'm even talking about things like car washes, which is what this came back up for in 1985. You know, ladies, we don't really wash our cars like that. That's a gender-based discrimination. So they were offering discounts but that also constituted gender-based stereotypes too. So we want to kind of stay away from that. And that's where the UNRRA for California came in. So California has double, we're going to separate California from the United States in several of these discussions because California has double protection as opposed to a lot of other states because of their state act that they've imposed. Looking at the weekly amount here, so almost 100 lawsuits per week this year. That is an enormous amount. And from January of 2022 through June 2022, we've had almost 100 lawsuits per week that went in front of a judge. And it's primarily related to internet web-based digital accessibility. So we're not even talking about the people who can't get into buildings or who can't access whatever else your counters are too high. We're not talking about any of that. We're only talking about digital. There are also lawsuits for physical space, physical accessibility, but that is not included in this report. So cases that were filed in federal courts, as well as those in California under the UNRRA, of course, are included in this aggregated data. Now, the UNRRA Act is expansive, and it came up in 1959, actually. And like I said, it prohibits any business from engaging in any unlawful discrimination. And since the passage of the ADA, disability access violations count among the practices that run kind of afoul uh, of the UNRRA Act. Combined with the California Disabled Persons Act, which is like a civil code, I think it's in section 54 because UNRRA is 51. The disability access plaintiffs are allowed to tack on state claims for money or financial damages onto the request of the injunctive relief in the ADA lawsuits. So even though they're filing a federal lawsuit, if they live in the state of California, they can also file several state lawsuits and get punitive damages from both sides. So the act allows plaintiffs to claim treble damages within $4,000 per access, plus any attorney fees. In most states, plaintiffs are entitled to only injunctive relief having the disability access issue if it's fixed or not. However, a lot of states don't, and you can even claim, like if you fail a class, then some of the claims are having the university reimburse you for the cost of the class and things like that. As a result of the damages claimed under the UNRRA California Act, they account for 42% of all of the ADA litigation nationwide. Okay. So California is half, and then the rest of us. Keep in mind though, California damages they can be reduced in certain cases to $2,000 or $1,000 if um the accessibility violation is corrected within a month or two of the individuals being served with the complaint. And you can see here where the number of cases actually like drastically, like 2018, we're at 2314, and now 2022, we have doubled. It's crazy. And this is only digital. The DOJ effect in 2022, and Following the DOJ, the Department of Justice announcement of its advice in March, the number of lawsuits filed in the state of Florida, they went crazy, going from 45 in the first quarter of 2022, which is from January through March, to over 100 in the second quarter. Now, during March of this year of 2022, consumer staples, retaining, and durables and apparel, they were targeted the most. So consumerism were hit the most. And only 9 plaintiffs were half of this month's website accessibility lawsuit. So looking at this month of, well, last month of June, half of those are websites are from 9 people complaining about a website. So this means we have repeat offenders. Pacific is a attorney's office called Pacific Trial Attorneys. They filed the most complaints in March. They filed 54 in California. So they're really taking advantage of this act federally and state. And most lawsuits, about 57% were filed in New York, with California coming in at a strong second at 38%. About 4% of litigated websites in March are using a third party accessibility overlay tool. We don't use a lot of overlay tools because a lot of our website is either bootcamp or they are LMS. So we're not using a lot of overlay. However, if we ever use, say, like a Google site or something like that, there is a chance that we could be using overlay, and we definitely want to avoid that. So if you ever see an overlay, which is like, say if you are want to check out, right? Say if you go to checkout and you hit go to checkout, and the checkout comes on top of the old screen, and it grays out that old screen. Have you guys ever seen that? Like you go to click something and it overlays the old screen, but you can still kind of see the old screen, but the new screen is highlighted. Yeah, that's an overlay. That we want to avoid those. If they're going to check out, send them to a checkout screen. Whatever you're trying to send them to, just send them there. Avoid overlays at all costs. And if you see a site within to you that has an overlay, just let Caroline know about it in QA, and she'll reach out to the right people to get that taken care of, because that is a huge risk. So the ADA, it applies, of course, we know, to Title II of the state and local government. So you hear that term thrown around for any ADA legal experts. And Title II does apply to businesses that are open to the public. That includes also Title III. So Title II of the ADA, it prohibits discrimination against people in all services, uh, programs, activities, state and local government predominantly. That includes higher education. Higher education falls under Title II, as we operate under Title II because we use federal funds and generally require students to complete a federal application for attendance at the schools we represent. That's where 2U comes into this great area. Even was our legal team was kind of like not really familiar with how to handle us when it comes to advising on where we fall. If one of our schools were to get sued that we created the curriculum for, where does that send us? Well, that sends us right along with them. So that puts, because we have an agreement with that school could also hold us liable for their, because we have nothing in our agreement with the institutions, which I spoke with Todd about an agreement with the institutions about where we fall if any legal litigations come into play. It is an issue in the industry with ADA because if anything happens with one of our schools, we can have a problem. We will have a problem if they so want to pass that on to us. So Title III prohibits discrimination against people with against any persons with by businesses that are open to the public. So that refers to public accommodation also under the ADA. So that's your hotels and your stores, anything that's open to the public, not necessarily that's private, and that's where ADA falls short. So if I have a private club, and let's just say I only want my private club to be of individuals of a certain ethnicity, that's perfectly fine. The KKK is fine. That's a legal club. It's a legal organization, not in the state of California, but in a lot of other states, it's legal to have a KKK. The NAACP, perfectly legal in some states, because some states are saying that you can't have even private organizations or clubs that are not given opportunity for all people to join, right? But under the ADA, they're saying private clubs, you can do what you want to do. You can have a club for women, you can have a club for men. It's a very gray area, and depending on what state you live in, it determines how the DOJ effect will occur. But as you can see, March they went really crazy, and this was all from one. Well, not gonna say all. This is primarily from one state and from one law organization. Any questions? Okay, so the top 10 law firms that represented, I cut one off, it's my bad. The top 10 law firms that represent the plaintiffs that's responsible for filing more than 80% of all litigations, and the top 10 defense law firms, they only handle a little under 15% of all cases. In the majority of cases, there were just 38 plaintiff law firms that filed on the behalf of 144 plaintiffs. I don't know if you can do the numbers in your head real quick, but that means 38 law firms that represented 114 plaintiffs. That means for the most part, each of these law firms were probably doing 3 to 4 each. So it was a targeted. That means they're targeting these types of individuals. Now, businesses operating in industries like e-commerce and food service, they, of course, have a higher likelihood of being sued due to the ADA's digital requirements than any other businesses that's operating in any other industry. Between 2021 and 2022, the area of healthcare advanced 3 spots, moving up fifth to third. So as you can see, that is, quite a bit there. And I call them ambulance chasers. I hate to use that word, but I've been through a lawsuit before. Even my comrade over at edX has been through a lawsuit, obviously, with edX before. And it is a monster. And it is something that can turn your whole career upside down. It can also cost people their jobs. So it's very detrimental and important. So the fact that many of the defendants have annual sales of less than 25 million indicates the requirement that the plaintiff law firms, they have to identify new businesses and to sue in order to maintain their volume of businesses. So not only are they targeting specific area of lawsuits, they're also targeting specific type of companies. They want the smaller companies because they know that they're more likely not to be compliant. So that's why they say no company is too small, because that's who they want, unfortunately. It's possible that this development is a result of a natural progression, but it might also be attributable to the shifting consumer habits. And honestly, many of the larger organizations have previously been sued and have accessibility initiatives that indicate a causal relationship. In this relationship, it can easily be extended to the more compact or small businesses. And the rise in e-commerce, it that may be attributed to the pandemic. It has led to an increase in the amount of attention that's being paid to less established but rapidly growing e-commerce businesses. So, when we were sitting home and we're thinking about, and we're not able to go into work or do things like that, there are a lot of these e-commerce that are popping up, and they are not ready for accessibility because they didn't know, they're not familiar with it, and they are at much higher risk because they're not even taking any steps toward trying to recognize that it's an issue. And so those are the ones that the law firms are really focusing on. Questions?
Yeah, kinda
Mhm.
kind of a question, but also thought with it. Commerce was so much higher than the rest of them. Uh,
Mhm.
and just thinking, and would you agree that it's because like e-commerce is such like a siloed industry in that sense? Like you're taking part in it like on your own. There's not necessarily like people around.
Mhm.
Um, so
Mhm.
if like something isn't accessible and like that's it because like you can't access it, then it's so much more likely that it gets reported. Whereas these other industries could possibly have issues, but it gets like fixed or like band-aid covered up because there's like people in person to like assist at the accessibility like in an instance. So then like issues aren't necessarily getting reported because it's like, oh well, I had an accessibility issue, but they were able to do like a one
Mhm.
for me because I had
Mhm.
so and so to help me.
Absolutely, you got it. And we know because I could open up an e-commerce business right now,
Mhm.
just sitting here and with no one, no oversight, no additional support. But it's much harder to open up an online school, for
Mhm.
example, without any additional help, right? So you're absolutely right. And I recognize that as well. I'm like, yeah, they're targeting mom and pop shops because they're literally mom and pop. and
Mhm.
there's no oversight. There's no third person say, "Hey, why don't you guys take a look at this?" Like it would be in, say, a much more robust online retailer or organization or nonprofit or something like that, where you have so many people that are looking at your work. So good point. Let's see. Where am I? Okay. So as of this point in 2022, 10% of the top 500 online merchants, they were served with a lawsuit already. 10% of the top 500. In the year 2022, there were already 50 lawsuits filed against these businesses. So some of them have already been sued, and the others have a suit that's been filed against them. So they're in the pipeline. So they really need to they really need to be targeted for e-commerce, and they need to be targeted for ADA education. I think that should be a requirement of the websites when they go to use these GoDaddies or Wix or whatever they're using to start their website. I believe they should be required by the website or by the provider to give them some type of course or class or something. I mean, this is just my opinion because as we can tell, they are being targeted and no one's watching or helping them understand what the problem is. So during the previous year, previous 4 years actually, 83% of the retail 500 filed uh, filings were lawsuits. So since 2018, ADA-based digital lawsuits were filed against 417 of the top 500. So we're probably going to surpass that most likely. And a significant year-over-year rise was seen in the number of lawsuits filed against businesses who used accessibility widgets for the entirety of the year 2021. I'm not against widgets, you just got to know how to use them. So UsableNet examined 400 different scenarios, and in these instances, the widget functionalities, they were cited as a barrier to equal access, in addition to other user site obstacles of WCAG violations, of course. But they widgets are a problem, and they need to be. You just need to make sure that they're accessible. That's it. Some people get the widgets because they're pulling it from somewhere else. They think immediately it's accessible, and that's not always the case. That's mainly the problem. So real quick, the methodology that they use at UsableNet were over 12,000 complaints that were filed this year. Okay, so from January through June, there's been 12,000 OCR complaints, and that's in the federal courts under the ADA and in California under the UNRRA. Um, they were reviewed by UsableNet, and the cases were examined in order to determine whether or not they included a digital property or a digital area of focus rather than physical one as the subject of the claim. So because of this, UsableNet is able to keep their customers more informed and offer them some most up to date, I guess you could say, up to date information when it comes to planning their digital projects. Look at how many people are using UsableNet. Not that many, especially considering that the lawsuits are aimed towards a particular type of victim as well as a particular type of organization that is doing the victimization. So I think that a much larger initiative need to be done. I believe that the website developers for these smaller or e-commerce organizations should be held liable, a little bit more liable than what they are. Okay, so any questions about that or any opinions about that?
I have a thought.
Hmm.
So, do you think that if the DOJ spits out a list of certain regulations, then are you saying that some unscrupulous law firms take advantage of those under the guise of trying to help people? And that could potentially skew the number of legit issues?
I don't want to say that because there are legitimate, I mean, the complaints are legitimate, right? The complaints are legitimate. However, I think that they are being targeted. I'm not going to say that they haven't done the violation. Sure, they've done. I wouldn't say they're unscrupulous. No, they're real legitimate complaints, but they are being targeted. They're being aim towards. And that's the only place that I have a problem. That's why the numbers are so large. Because there are some ambulance chasing law firms that are only they'll enroll students in a school that they know does not have accessible LMS so that they can sue them. That's and there's been one specific, I don't want to say their name, but it's been one specific organization that has been found to do that. And they got in a lot of trouble for doing it. And they are out to help people. However, they were also enrolling students in schools that they knew could not accommodate their disability or their uniqueness in an effort to sue, and they were getting monetary kickbacks for that. But does that mean that the complaint isn't real? No, the complaint's real. It's just that it was a target. So I don't know. It's kind of like, I'm still kind of on the fence about how I feel about that. I don't think that we should go out and target certain people. That's kind of like the stop and frisk that we had back in the 90s. Remember, they're like, oh, you look suspicious, so I'm going to stop and frisk you because of the way you look. And it's even if you have a gun on you, you know what I mean? Say you do have a gun on you, you have drugs on you, whatever, and the stop and frisk work. Does that still mean the stop and frisk is right?
So what you're saying is then they're all legit, but the motivation behind some of them is questionable.
In my observation, that is correct, Anna.
Okay.
I don't believe that it's not because students or because consumers have called OCR and said, hey, the Office of Civil Rights, and said, hey, I'm trying to order this thing off this website, and they don't even, a lot of them don't even know how to go about doing it. They have to have someone to help them. So a lot of times it's organizations will throw out these, or law firms will throw out advertisements and say, like, if they, online ads, like, are you having a problem accessing the website? Are you have, just to get you, we might not see those because we are not in their target audience. So we might not see this. Say we're looking at Facebook or if we're looking at whatever, we're not going to see those type of ads. But if you are visually, and I have a student who is, and she gets totally marketed to for law firms that are like, are you having a hard time accessing this and going to there, or are your online classes um, not accessible? And so I know that it is a targeted advertising campaign, and it has to be for financial gain. Otherwise, these law firms wouldn't be doing. Doesn't mean that sometimes my student does have problems accessing some things. However, she was targeted to, she was advertised to sue. So that puts everyone at risk who has any type of online e-commerce, anything digital. Not in addition to physical space, but digital more likely, because digital is much more of an easier target, especially for those of us who would start a small digital company. Any other questions or opinions? All right, so I'll share this. Actually, it was I believe it was what do you call it? It was like a graphic. It was an image. I turned it into a PowerPoint. So I'll share the image with you all. You can take a look at it and think about, how that might affect you and your work, and who you have conversations with, and maybe we could change the conversation a little bit different and just try to get as many advocates as we can around, building accessible products in a digital space. We're not legal. We're not lawyers here. We do have some legal knowledge, but we're not lawyers here, so we're not giving legal advice. What we're doing is just stating the facts and stating the research that's been done, and that I think that's the area that we should stay within. Just stating the facts, stating the research that has been done, and the measurable, quantifiable data that has been put out there for us to look at to make the best decisions for our practices, right? All right. So if there's nothing else, you guys, I will see you all next week. If you think of anything before then, please feel free to send me out a note or email or shoot me an IM or whatever. I'm always available.
Thanks, Kianda.
All right. You're very welcome. Talk to you later.
Bye.
Bye
Have a good
bye.
weekend.
You too.